For the first time since overturning Roe v. Wade, the United States Supreme Court will take up the issue of reproductive rights, announcing this week that it will decide on the availability of mifepristone, a commonly used abortion pill. But until the court issues a decision, the FDA's approval, as well as current levels of access to the drug, will remain in place. But the status quo is not a luxury many women seeking an abortion in states with restrictive abortion laws can afford. Women like Kate Cox, the Texas mother of two whose fetus had a rare genetic condition that almost always results in a miscarriage or stillbirth, and also put her own health, including future fertility, in jeopardy. While the state's Supreme Court put a trial court's ruling allowing Kate to get the procedure on hold, she continued to have medical complications, and finally she was forced to leave Texas for an abortion. And because the Texas Supreme Court, comprised of 9 male Republicans, doesn't care about women's health, it eventually ruled against Kate Cox. Joining me now is Mini Tamaraju, president of Reproductive Freedom. Mini, let's start in Texas. The Supreme Court's ruling seemed to contradict its own authority. So check out this line from its opinion. Quote, the state legislature has delegated to the medical rather than the legal profession the decision about when a woman's medical circumstances warrant this exception. But Kate Cox's own doctors, who last I checked are part of the medical profession, said she medically needed the abortion. So what does that tell you, Minnie, about how that court and others, frankly, will ignore its own legal reasoning to achieve a desired result?
You know, when I was in law school, Katie, my professors kept telling me, don't interpret this for political reasons. This is an impartial judiciary. Remember those days? And you would think that the Supreme Court would interpret the law correctly. However, I posit this, you know, the Texas legislature, frankly, seems to have had no intention of enforcing or making enforceable these exceptions. These exceptions of medical necessity were designed not to work. So you could say the Texas Supreme Court is doing exactly what the law was designed to do. And this is really important as we are going across the country, state by state, fighting for abortion rights. And Republican extremists are saying, well, look at this ban. It's not really a ban, it's a limit, but it has these exceptions. We have to question, when is a ban not specifically a ban, and exceptions, when do they work? They are designed not to work. They are designed to create harm.
This is such an important point, Minnie, that I really want to stay on for a second and emphasize, because to what you're saying, a lot of these legislators say, but we provide for these exceptions. So what's your problem? We're giving you an out if you need one. But in Texas specifically, her doctor said it was her good faith belief that Kate met the abortion exception. But the court said good faith belief isn't the same as reasonable medical judgment. So the people that are drafting these laws, Minnie, they are intentionally making them vague. They're making them vague, so vague that you could drive a Mack truck of political intent through. And then the courts, typically, that are, conservative leaning, they're interpreting those vague laws to fit their own purpose. And so where's the recourse then? Like, where's the justice in this?
There's no justice. I mean, Kate Cox had to leave the state. You know, Kate Cox had the privilege and the means in a terrible, disastrous situation to leave her state. I'm from Texas. I can tell you the majority of women affected by these bans, women of color, women in, rural areas, women who are marginalized from care, they could not leave the state and get their care, right? They are prohibited from it by cost, by the fact that most mothers who have abortions, like Kate Cox, already have children. How do you get the childcare? How do you travel? I think the other thing that's important to note about the Kate Cox case is that her pregnancy is later in term, and there are increasingly limited options for pregnancies later in term. I think there's only 10 states right now, I'll have to double check my numbers, where you can get such an abortion.
Let's talk about the United States Supreme Court, its decision to hear in this term those 2 mifepristone appeals. Were you surprised at all that they decided to take up those 2 appeals?
No, I mean, it's a mixed bag. We would have preferred for the court to dismiss the case, right, and say that vacate the lower court decision. But look, now that the court has taken the case, there's a couple of things for American people to watch out for. This is an incredibly radical extremist court. This is a case that they accepted on narrow terms on standing, right, Katie? but we should be concerned regardless. You know, the mifepristone case came out of Judge Matthew Kacsmarik's court in Amarillo. It's been questionable from the start whether there was any credibility, any standing for this case. The fact that it made it this far is alarming. This is a case extremists have tried to bring to the court for over a decade, and only this extremist judge, Kacsmarik, took it. This case is what we've been calling a backdoor abortion ban. What that means is instead of going after the legality of abortion, they're going after the FDA authorization of the drug. Again, mifepristone is the most popular form of abortion, most widely used. And in this increasing access climate, it is easier to get because of telemedicine. So taking this and questioning this access and this authorization could have devastating consequences for the entire country, including in states where abortion is protected, like California and New York.
And Minnie, your fears are well-founded. There's that blockbuster reporting that came out in the New York Times about how the Supreme Court gutted Roe v. Wade and all of the backdoor dealing that went on to be able to get that result. To what you're talking about, the narrow issue that was originally brought forward in Dobbs ended up getting bigger because of that conservative majority driven to be able to make sure that it overturned Roe v. Wade. But in this instance, for the mifepristone cases, though, the Supreme Court said they weren't going to take up the total ban on being able to access it that Judge Kacsmarik basically said was going to happen in terms of the FDA approval that was brought in 2000. Do you have a concern that because the Supreme Court has agreed to take these cases, that maybe they have more of an ulterior motive in terms of expanding prohibitions against mifepristone access?
I mean, absolutely. We'd be foolish after looking at that New York Times investigation to take this court at face value. You know, what was so fascinating to me, Katie, about that report, incredibly well done report, is that it was clear that the justices were concerned about political optics. It's clear that Amy Coney Barrett raised that concern coming right after Ruth Bader Ginsburg, that she was going to be labeled as somebody who was taking advantage of the political moment. And yet they did it anyway, right? Justice Roberts did his best to try to, quote, moderate the case, which frankly would have still been incredibly devastating. And yet they proceeded despite what they knew would be negative public opinion. This is a court that has shown it does not care about precedent. It's not flinching in the face of public opinion. You know, we've been running a campaign with our colleagues across the reproductive rights, health, and justice community to educate the American people on mifepristone. We're hoping that combined with the pressure from the pharmaceutical industry to not undermine the FDA's authority will be helpful here. But I got to say, this court is hard to be trusted, and the American confidence in this court is at the lowest levels yet.